Welcome to Simplifying the Complicated. In each episode, we'll get together with other professionals and have fun talking about trust and estate matters. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, lawgbs.com. Now here are the hosts of Simplifying the Complicated, Lori Bolander and Lauren Gallagher.
Hello, welcome to Simplifying the Complicated. I'm Lori Bolander.
I'm Lauren Gallagher.
We're going to talk about issues that surround the area of trust and estates law. Today, we're going to simplify the complicated around special needs trusts. This is a complicated subject in our practice area that we know a little bit about and deal with occasionally, but really just enough to be dangerous, really enough to know when to bring in somebody that really knows this area of the law thoroughly. And so today we have somebody here today that knows this area, and that is Carly Maganuco. Welcome, Carly.
Hi, thank you.
So Carly recently joined our firm. She's an attorney, and she's actually a certified specialist in trust and estates. And we're very excited to have her at our firm for a lot of reasons, but also because she has this concentration in special needs trusts. So hopefully she's as excited to be with us.
Of course
as we are to cover. So how you doing today, Carly?
Doing great. Ready to talk about all things special needs trusts.
Yes, I know. Fun topic. And like I said, we do this in our practice area because this comes up frequently with beneficiaries and estates and when we're doing estate planning. But can you just explain what a special needs trust is and why people would need one?
Yeah. So special needs trust is much like other trusts in that it's a trust agreement. It's its own little entity that holds property. The big distinction is that it's created to provide for somebody with special needs, just, a disability, what have you, with the very specific goal oftentimes of preserving a disabled person or folks with special needs, their access to public benefits, assistance through the government, whether that's a state-run program or a federal program. So they're very, you have to be very careful with them because they do require very, very specific language to maintain eligibility and preserve those benefits, both federally and state specific.
And there are different kinds of special needs trusts, the first party and the third party. Can you explain the difference between those two?
Yeah, so the most simple difference is a third party special needs trust is created by somebody other than the person with the special needs. So the easiest example is somebody's mother and father. They create this trust while they are still alive to benefit their child with special needs so that someday when they're no longer around to take care of them, that's set up. It's funded with mom and dad's assets. Sometimes it can be funded with other folks' assets as well. First party it's self-settled. It's created by the person with the disability. And then it's funded with their own assets. Most commonly, somebody who receives an inheritance that wasn't structured to arrive to them through a special needs trust. They put that in their own first party special needs trust. Again, the different types of trusts have very different requirements. So we have, the overarching tree of special needs trusts. We have the first party, which there are multiple kinds of first party special needs trusts. And then we have the third party. Each of those have their different rules and requirements for what must be included.
And don't the first party generally require like a court order to create them?
Not always. So sometimes, especially if somebody is lacking capacity or there was a lawsuit settlement, sometimes it's created that way. Most commonly in my experience, it's been, I'm just drafting a first party special needs trust with no court order for the person who is sitting across from me who has the capacity to at least understand why we are doing this. But let's say they have a physical ailment that, they really, really need to continue on their public benefits like Medi-Cal or SSI, something like that. So not always a court order required.
So what's the main difference at the end?
At the end, that's a good question. So with a third party, folks use the assets for the benefit of the person with special needs. When that person passes away, if there's anything left, that goes to whomever else is listed as the person to receive it, persons to receive it. So the remainders. For a first party special needs trust, to qualify as a valid first party special needs trust, it must have a Medicaid payback provision. And so what that means is if that person has created this trust, funded it with their assets, utilized, let's go specifically in California, they've utilized Medi-Cal. When that person passes away, Medi-Cal is notified and they look to the trust. If there are assets left in that trust, Medi-Cal gets paid back first. If there's anything remaining, then it can go to whomever they named after that. So,
and that's very different than the third party, right? So the government doesn't have a right for reimbursement.
Correct. So you have a lot more control over a third party.
So it's really important for folks like that who are on government benefits and want to continue to have whoever is going to give them money or the benefit of some money set up correctly so that there isn't that right of reimbursement.
Exactly.
We obviously see this mostly we see it in two contexts: estate planning, and then also when we're administering somebody's trust. Mom or dad has died and we have somebody with special needs within the trust. And often it might be an older trust and there is no special needs trust. And but we know that if we give this money to disabled son, he's going to get disqualified from his benefits. If he turns around and sets up a first party special needs trust with that money, is there still a period of ineligibility?
There could be, yes. And so this is where it gets kind of tricky and why, some folks do try to do this on their own, or like you said at the top here, when you know enough to get yourself into trouble and be dangerous. All of the different programs have very different rules and what renders you ineligible or penalizes, you for X amount of time. So it's really important that if, somebody's passed away and there is a trust and you're not sure what provisions are there, it's really important to contact somebody that knows what they're doing pretty quickly. I've, had experience in going to court to resolve that and limit any periods of ineligibility. It's less of an issue with Medi-Cal, more of an issue with Social Security benefits these days. But, I've also had folks who waited a long time to deal with a loved one's trust. And, we have to look back and go, oh, you weren't actually eligible for all this time. And that could sometimes be a problem. Yeah,
absolutely. I know. And I sometimes have clients that say, well, what does it matter? We'll just give it to them. Not what does it matter if they get disqualified? They can live on the money. But the problem is then they have to reapply for these benefits, which is a whole big hassle, and they may not get the benefits for a long period of time. And so that's kind of where the problem comes in, is you're really, by giving them this inheritance, which usually is not going to last them their whole lifetime, right?
Right.
And if it's significant enough that it would, then maybe they don't need government benefits, so maybe they don't need a special needs trust, right?
Right. And so much of the focus oftentimes is on, that preservation of eligibility and access to public benefits, but those benefits aren't always, the benefits of a special needs trust aren't always just the money side of it. There's a lot of other things that we think about when we're drafting these. And one of the conversations I have most frequently with clients is, okay, we know the nature of the disability now. what happens 10, 20, 30, 40 years from now? Is it progressive in nature? Will, your child lose the ability to manage certain aspects of their life on their own? And how do we plan for that? Because, we practice in this area, we see the failure to adequately plan in advance. And ultimately, maybe we're looking at a conservatorship where we wouldn't necessarily have to, things like that. So I always, and it's always my goal, not just for the public benefits, that's obviously paramount to most everything that we're doing when we're drafting these, but I also look to things like, how do we create a team? How do we create flexibility? This trust may have to go on for decades after mom and dad have passed away. And there's a lot of creative things we can do. We can bring in other roles, not just a trustee. We can bring in trust advisors, trust protectors, care managers. So just saying, a parent who says, it's fine, they'll get a couple $1 million, they can live off that for a while and revisit their benefits. It's really important to realize that there are a lot of other factors.
You can have kind of a built-in management team.
Yeah.
Exactly. Nice, neat entity to deal with that.
Exactly.
Can you explain why a special needs trust is helpful? Like, what does it do exactly? How are distributions made and calculated and helpful to that person?
Yeah, I mean, looking, obviously, it's so hard because there's such a spread of different people with different abilities and needs, really. It's really hard. It's not a one size fits all. So oftentimes, it's nice to do the advanced planning so you can sit down with the family, bring in the trustee in advance so they know kind of what that person's needs are, what their budget is, what resources they have available to them, what the actual benefits are that they are on, because distributions that are made really depend on what benefits are on. So, for example, I've seen fairly valuable special needs trusts with a beneficiary who is accustomed to certain outings and vacations and things like that. He was able to drive, and we look at, okay, well, what's in the trust? What's his life expectancy? What's going on here? And we tailor things based on that. Some folks have greater needs than others. Some folks, have greater resources than others. So we're really looking to the individual.
So the idea is that the beneficiary continues receiving their public benefits, and the special needs trust assets are there to supplement their needs. So it's there to add on, pay for things that their public benefits don't pay for, make their life more comfortable.
Exactly.
And is there guidelines for that?
There are guidelines for that, and those are always changing too. So specific to, for example, SSI, which is a means tested benefits program under the Social Security Administration, it's what's called in-kind support and maintenance. There are certain things that you cannot pay for. And if you do, it will actually reduce their monthly benefit. Well, there was a recent change. I want to say it was at the end of the summer that went into effect. I want to call it 9/30. It went into effect that says, well, for the longest time, if somebody gave you food support, paid for food, provided food, your benefits would be reduced. Food is no longer included in that standard. So it's always evolving. It's always changing is really the message there.
And it depends on what kind of benefit they're on as to what distributions are allowed.
Exactly.
Like for SSI, it's supposed to be like housing was food, your basic living needs. Because I know I've had situations where we've had the special needs person living in the house and they've actually reduced for free. And they've actually reduced their benefits because they're getting basically an in-kind. They're getting shelter for free, so they don't need that extra money. And they don't get that much, so that's why it's so ridiculous. But then they'll, reduce it even more because So I've had some situations that I've seen where they come up with something where like they pay a like reduced rent just so which kind of half a dozen of one and six to the other. But and Medi-Cal has changed a bit too in California anyway, as far as eligibility and all of that. And do you know the specifics on that? I've looked it up 100 times and never remember, but
yeah, big changes. So for the longest time, they had a very similar but different asset test for qualifying for the programs. As of the first of the year, that asset test is gone. So there is no longer an asset test to qualify for most Medi-Cal programs. So we look at Medi-Cal, it's this big umbrella, and they have a lot of different programs for different needs, different, there's long-term care Medi-Cal for skilled nursing facilities. There's the assisted living waiver program. There's all sorts of programs. They did away with the asset test. There are still income.
So before that, if you had to spend down all of your assets down to like nothing, right? 2,000 or something.
It depended. Sometimes there were things we could do. If it were a married couple, for example, we could go to court and actually increase the amount of assets that a person was allowed to have. But yeah, a single person could have $2,000 in countable assets. So that was a similarity between Medi-Cal and Social Security, specifically SSI, is they categorized assets. You could have a house, that's fine. That doesn't count against you, but the cash in the bank does. So Medi-Cal getting rid of that asset test was great. We do still have income considerations depending on the program and share of cost and all sorts of fun math things. But yeah, much more access to those programs now. So there are less concerns about that, but I don't think that that's reason enough to not set up a special needs trust.
Right. Yeah. As far as Medi-Cal goes too, so now they're only looking at income, right?
Sometimes. So not always.
Right. It depends. And that's what you mentioned the word countable assets. And that's a whole nother like area that is complex because I've looked at that before too, like figuring out, well, does this asset, is it counted for this program that this person wants to be on? And, when I start going down on these rabbit holes, before you work for us, that's when I'd be like, okay, I'm referring this out to Carly. I don't know what I'm doing. This is way too complicated.
Yeah. Well, and again, it was a great change and I was really happy to see it happen, but the plot has kind of been lost a little bit because people were so excited about that, not remembering that SSI still has their incredibly restrictive rules. We've still got those resource limits, very low resource limits to qualify for things like SSI, which so many people need. So
yeah. Absolutely.
What kind of things can you use the special needs trust for? Like, what is an example? I've heard of a nicer bed, a nicer or electric wheelchair, dental work. Are those kinds of things? Like, what else qualifies for uses of that special needs trust to benefit that beneficiary?
Well, so I think it's really important to know that a special needs trust to qualify as a valid special needs trust to preserve somebody's access to benefits is that it has to be completely discretionary, meaning the trustee has 100% discretion to do what they want. Obviously, guiding a trustee along the way and making sure they don't do something like, in the past, I forget where I heard this, but when I was first learning about SSI, because it's very complex, I still get confused. Somebody had told me, well, the trust can buy the movie ticket, but it can't buy the candy. And I remember just sitting down, what? Really? So that's an illustration of how careful you have to be with what you pay for for sure.
Yeah. And where are those guidelines? Are they easy to find? I bet I know the answer.
No. Yes and no. The Social Security Administration, they publish their procedure manuals. Like, it has the rules there, but I mean, we're attorneys. We do that. We can read the rules, but actually applying them, sometimes there's a difference there. So
what kind of watchdog is there for this?
Yeah. So Social Security, they are far reaching. The administration is far reaching. If somebody is receiving benefits, I've seen when you set up a special needs trust and the beneficiary is on, for example, SSI, they request a copy of the trust. They presumably could review. You have to report what your trust is paying for, what you have, your resources, all of that. So they're pretty, their scrutiny is pretty high.
So do you have a mandatory, if you're the trustee of that trust, do you have a mandatory accounting requirement?
Yeah. So you do have a mandatory requirement to account to the beneficiary. Okay. I, in my experience, have not had the administration seek one.
Oh, that's good.
So I actually don't know the answer to that question. The times when I see the administration get involved, that I have seen the administration get involved, is when you have a situation where somebody's the rep payee, the representative payee on behalf of the beneficiary. There, you are accounting to them. You're showing them what they've done with the money. So
a lot of times the trustee might also be the rep payee.
Right. Yeah. Right. Exactly. But like I said, even if they haven't done it, I would not mess around with that at all.
Yeah, because you could, get in big trouble.
Yeah,
not only just disqualify your beneficiary, but like actually, get in trouble.
Fraud.
Yeah, exactly.
Yes.
Oh my gosh. Yeah. So, I think everything we've just talked about just goes to the notion of, like, if you're appointed as trustee of one of these trusts, you need to make sure, like, you know what you're doing and have proper legal representation and know what you can make distributions for, because I know I've had clients over the years that have said, oh yeah, I'm trustee of my brother's special needs trust too. Like, it's no big deal. And, I don't think, I'm like, oh, that's pretty complicated. Oh no, it's no big deal. I have no idea how those ended up. Right. But
I think one of the issues too is that trustee might have had it nailed at that moment in time, but the law changes on a pretty regular basis. Right. And unless he or somebody in that position is consulting with an attorney like Carly, who stays up to date on these issues, he could be completely out of compliance and putting himself on the line, his neck on the line, and the assets in the special needs trust and the public benefits.
Yep.
Yeah.
Exactly.
Yeah, absolutely.
Exactly.
I sometimes have people that I'm doing estate planning for, and they'll come in and they'll say, well, we want to do our trust, but we want to set up a special needs trust for our daughter or son. And, that's, again, usually when I will refer them to somebody else for that separate special needs trust. But, a lot of times when I start asking them, okay, so you're going to put money in that now. And they're like, well, no, we don't need to put money in it now. We just want it for later when this inheritance comes to them. And so what we've started doing, I think it was common practice years back, that you put like a sub trust in of the special needs, right? The special needs subs trust. And then the trustee would distribute that beneficiary's money over into their sub trust. But because the law changes so much, we've started just giving like the trustee the power to create one at the time, because that way it's all up to date and complying with all the laws. Yeah. And also there are sometimes beneficiaries that become disabled later, and we
didn't have a clue.
We didn't have a clue that they would be, right? So I think that practice is helpful because it probably keeps more trusts out of court, because like you were saying, you have to go to court to like sometimes fix these to make them
Modify.
comply. And yeah.
Mhm.
But I get that a lot of like, oh, we want to set it up now, but they don't really realize like, no, they don't really want to set it up now. Is there a benefit to setting one up, you know, while you're alive for your child, for your own child when you're
Yeah. So, I mean, to your point, something that, I learned early in my career is having that ability, what we call a standby special needs trust, having that ability to create that trust, have that trust spring out if needed is critical. I really, really, really dislike creating a trust and sending it out of the door with the client that doesn't have one of those in it, because like you said, we never know. We never know. And usually when you explain that to the parents who are creating this trust, they get it. They understand the need for it. Some folks, and I have done many standalone, just on their own third-party special needs trusts. One of the benefits to doing that is if somebody else wants to contribute to it. So a grandparent, a friend, whomever, you've got this thing there. It's already named. It's already in existence. That's often the most common reason why I, at least, do a standalone special needs trust, but usually the sub-trusts or the standby suffice.
So if you set up a standalone separate or a special needs trust while the trustors are still alive, I've had this situation recently where this was set up years ago when the parents set up their original trust, but then fast forward at least a decade, those terms were kind of stale or they weren't up to date, and the trustee had to go to court anyways to get it updated. So for those kinds of cases, is it possible, or those kinds of trusts, is it possible to put language in those trusts that gives the trustee the authority to amend it to comply with current law or current circumstances?
So I have had, for example, there was one I can think of that we included authority for the trust maker to, up until it was funded with a certain amount of money, and so long as, the trustor was still living, they could come in and amend certain portions of it. So there are some creative ways around that. Eventually it will be irrevocable, and then you might be looking at going to court to modify that and make sure it's in compliance. I mean, the simplest things can really screw up one of those trusts. And when I say the simplest things, the word may instead of shall, things like that. And so
yeah, I don't think people realize the importance of those two words. They mean a lot.
Yeah.
They're not just filler words. They actually have, impact.
Yeah.
Yeah. Very big impact. Very, very big impact. So I think a lot of these conversations, we're pointing to, because one of the questions that I was going to talk about, I was like, how important is it to have like an attorney draft this for you, as opposed to just trying to throw something together? But I mean, I feel like that's a little self-evident in everything we've talked about. I mean, it's like you shouldn't even be administering one of these trusts without an attorney, let alone drafting one. And there are plenty of attorneys that don't even want to draft them because they're so complex and everything changes so often.
Well, yeah. And in our general practice, handling a more what we would often refer to as a vanilla trust administration with no special needs beneficiaries. I mean, how often do we see somebody who tried to do it themselves, whether it be the drafting or started the administration and ran into a roadblock? It's not a very simple consumer friendly area. And there are so many pitfalls. Generally, I feel the magnitude of those, of the consequences of trying to do it yourself in the special needs world it could be incredibly detrimental to the beneficiary.
And even if you, even just with your regular estate planning, not special needs planning, life changes, the law changes, circumstances change. A decade ago, I don't think any of us would have contemplated digital assets and cryptocurrencies
Right.
and things like that. So just kind of for your basic estate planning, although you've done it and that's great, there's always the benefit of having it reviewed periodically. And it seems like for special needs families or, people who have special needs beneficiaries, it's even more critical to have those documents reviewed regularly to make sure that everything is compliant. And we're not going to do all this and then find out later we still have to go to court.
Yeah, right. Exactly. Unfortunately, it does still happen, but a lot of those things are fixable. A lot of them, some are not as easily fixed, but yeah, I mean, we could still end up there if you're not vigilant about that. I've found that folks that know that they need one of these for their loved one they understand the importance of it more often than not. So that's good. But I think that also expanding that into just the regular estate planning world is important. Like you said, it's having these things reviewed with some frequency is pretty important.
Yeah. What should people consider when choosing the trustee of their special needs trust? Because we've kind of talked about the trustee and making sure they know what they're doing or getting advised or whatnot. But what do you generally recommend for people?
Yeah. And so this is always tricky. This is honestly one of the trickier parts of creating these. So often I have, parents who have 2 children, one with special needs, and they say, oh, well, our child's sister, our other child will just manage it. And I'm looking at them, maybe that sibling is young, off at college. And I'm thinking, well, what if something happens tomorrow? Are they really at a point in their life where they can step in and manage their siblings' needs? I have no doubt the love is there, but do we want to put that on that
It can
person?
be a lot of work to deal with, a special needs person and their life and their needs,
Exactly. And then, we don't know what their future holds either. Maybe they'll get married. Maybe they'll have children. Maybe they'll have a demanding career. So what I typically tell folks is if you want to name the sibling. That's okay. But let's put in, options, mechanisms for appointing successors that maybe fit the need at that time once it becomes relevant. So, appointing a mechanism in there to appoint a professional fiduciary. There are lots of great fiduciaries out there, professional trustees that really know how to access community resources, the healthcare system, things like that, and manage people with very special needs.
And to be honest, having the knowledge of where to find the answers to some of these questions and what places you need to go. I mean, because I've worked with some of these fiduciaries before, when they're dealing with these special needs trusts, and they have. There's things that I didn't even know existed.
Yeah. Well,
and they are like, yep, we got to go get them this and that, and and they know all the little things. There's extra benefits sometimes these people can get that most people aren't aware of.
Yeah.
So some of them really do have a niche within the special needs trust, world.
Absolutely. And that's not to say there's not a place for the sibling on the team. Having them as a trust advisor, somebody that, it's spelled out, hey, trustee, you're doing the day-to-day, but please consult with our child because they are very familiar with their siblings' needs and what's important to us as the ones leaving this legacy and these funds, these assets to benefit, our child. So there's a lot of things we can do to.
And we've talked about professional fiduciaries on many of these podcasts with various professionals. But sometimes it's very difficult to talk people into like some quote unquote stranger managing, their disabled anybody, their trust in general, but let alone their disabled child's, trust.
And that's valid. I would be wary too. That said, much like us as attorneys, we won't be around forever. And so many people say, oh, well, when I die, my kid can call you. And I'm thinking, well, you're in your 40s, so you're not much older than me. And I hope to be retired by the time you pass away. So, don't get attached. It's the same thing with fiduciaries. Yeah. I've had clients who want to specifically name a fiduciary, and we set them up with interviews, and they meet people and they find somebody that they are comfortable with. And that's fine. I'll name that person if they agree to be named, but I'm still going to want a mechanism in there to appoint somebody.
Absolutely.
And that's sometimes where, the sister can come in. Like, how about we have sister interview the fiduciaries at the time they're needed? And, the people, the ones that are actually working at the time, and they should appoint somebody,
Right. And that's why I just like the team approach when it's appropriate, and doing this in a way that really gives us the most flexibility as possible. It's so important in these cases. Flexibility is so important.
It is. Well, I think we could probably continue talking about this because there's so many little, holes and niches and things that with all the different special needs trusts, the benefits and the trust and the type of trust and the things that we need. But I think we've gotten a pretty good overview today. So I appreciate that, Carly. It's, I learned some things today that I didn't know. And I always want to know more so I can help my clients. And, even if it's just to know that they need to go talk to somebody like you to get this worked out, Yeah. So thanks for joining us today. I hope everybody enjoyed our discussion and hoped that and found that we simplified some complex issues around special needs trusts. It's definitely a complex area. You can find Carly and us at lawgbs.com. And thanks to everybody that tuned in today.
Thank you. Thanks, Carly.
Thank you.
You've been tuning into Simplifying the Complicated with your hosts, Lori Bolander and Lauren Gallagher. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, lawgbs.com. Thank you for your positive feedback, comments, questions, and for sharing this show with others.